Good afternoon, my lord. My name is Forsyth, and I appear on behalf of the pursuers. My lord, this case is calling today for a pursuers debate. I would ask your lordship if he could have in front of him numbers 8, the record, numbers 9, the Rule 22 note, 5, the pursuers productions, and 12, the list of authorities, as these are the documents I'll be referring to throughout. My lord, before I begin, could I please ask if you had had a chance to read the record before today's calling? My lord, this case is about a sale of goods contract. The value of goods provided to by the pursuers, is £43,200 sterling. However, today's debate is specifically on the issues of offsetting a liquid debt. Offsetting a liquid debt off of an illiquid debt. This is a reference to contract 11, seen at 5.1. I will be inviting my lord to grant decree of the sum of £39,600 sterling. This is taken into account the disputed contract at 5.11 and the contract seen at 5.13, which was delivered back to the pursuers' premises. My lord, I also note at condescendence 2, at the beginning of page 3, approximately 6 lines down, I'm going to move to change the word pursuer to defenders. My focus today, my lord, during this debate will be liquid and illiquid debts. It is my belief, my lord, that in Scots law a liquid debt refers to a debt that is certain in amount and is easily measurable or ascertainable. The term liquid essentially means that the debt is clear and not subject to dispute, or the amount owed can be determined without the need for complex calculations or lengthy legal proceedings. This could include a fixed sum of money that is due for repayment, such as outstanding loan or invoice, where both the amount and the obligation to pay are unequivocal. On the flip side, my lord, an illiquid debt is subject in Scots law refers to a debt that is not certain or easily ascertainable in terms of this amount. Unlike a liquid debt, which is fixed, clear and measurable, an illiquid debt may involve complexities and uncertainties that make it difficult to determine the precise amount owed without further investigation, calculation or legal processes. An example of a liquid debt, my lord, could include disputed debts where the amount owed is contested by the debtor, or there are unresolved issues regarding the debt's validity or terms. Debts that require assessment or valuation, for instance a debt linked to damages that must be calculated before being valued. And finally, a debt based on complex contractual terms, such as when there are multiple factors or contingencies involved in determining the debt's value. Thus, my lord, the pursuers supplied goods to the defenders on 12 different occasions, and the sums sued for are all liquid sums. The defenders' counterclaim in regards to the contract seen at 5.11 is an illiquid debt, as the claim for damages, that sum is unknown until the court makes a decision on it. The pursuer's claim for payment for goods supplied is a liquid debt. My lord, it is my understanding of the law that as liquid and illiquid debts, illiquid debts are different types of debts, one relating to an identifiable value and the other one that is not clearly ascertainable. They cannot be offset against each other. In the Law of Contract in Scotland by McBride, 3rd edition, W. Green 2007, at paragraphs 1463, it states that damages are an illiquid claim that should be set off a contractual claim. This paragraph goes on further to state that damages cannot be a counterclaim in an action for a contract price and cannot be used as a defence for an action. for that action, sorry. At paragraph 2062 of McBride, it states that when a performance of a contract being withheld is payment of a debt, the Compensation Act of 1592 allows liquid debts to be set off against each other. However, it does not apply to illiquid debts. In a mutual contract, parties may withhold performance when they have illiquid debts, not because of the Compensation Act, but because of the mutuality principle. McBride goes on further at paragraphs 2067 to expand on the principle of mutuality, and he states that the principle of mutuality of obligations applies to all contracts, and so in any type of contract, a claim for the sums due under the contract may be met by the defence that the defender has claims arising from the pursuer's failure to fulfil that contract. As you can see from the record at 8 of process, the pursuers did not fail to fulfil the contract, and therefore the defenders cannot reasonably rely on the mutuality principle as a defence in withholding the sums due for the goods by way of the counterclaim for damages. I would like to refer, my lord, to the case of Purac Limited versus Bizac Limited 2004, and that was reported by the Scots Law Times at 37, and this case was decided by the Outer House of the Court of Session. Here, Bizac Limited accepted that the sums were due to the pursuers in line with the contract, but the agreement was to offset the net balance of any defective performance made by the pursuers. The sums due for that contract were a liquid debt and were clearly identifiable as £385,594 and 1 pence in sterling, whereas the amount to be offset by the defective performance of the pursuers was an illiquid debt that was not easily identifiable. It was held that the consortium agreement itself was not sufficient to achieve the results that the defenders were looking for, but that the breaches of contract were clearly substantial. This is similar here, as the defenders are trying to offset an illiquid debt against a liquid one. They are stating that the breaches of contract would permit them to do so, as seen in this case. However, there was no breach of contract by the pursuers, and thus the defender's defence is irrelevant here. I would also like to refer my lord to the case of Barnton Distilling Limited versus Barton Brands Limited of 1993, and that case was also reported by the Scots Law Times at 1261. This again was decided by the Outer House of the Court of Session. Here the defenders used the loss they had suffered, the sum that they were counterclaiming for, as a defence for withholding payment for a supply of whisky that they had received. They based their withholding of the sums on the mutuality principle. It was held that the mutuality principle could be extended to 2 different contracts if both parties agreed, but there must be sufficient evidence to prove this. This case is also similar to the one being debated on today, as the pursuers are suing for sums due to them for a number of contracts for the supply of tar macadam, and the defenders are withholding payment on the basis of the mutuality principle and refusing to pay due to the issues around the supply on the 26th of November in relation to the contract seen at 511. There is no evidence of the 2 parties agreeing on the mutuality principle extending to multiple contracts, and again, it is my opinion that the defender's defence is irrelevant. Finally, my lord, I would like to refer you to the case of Inveresk plc versus Tulis Russell Papermakers Limited in 2010. This one was reported in the United Kingdom Supreme Court at 19. this case was decided by the Supreme Court of Scotland. Here the parties had a contractual agreement involving the sale of paper goods. Instead of paying the sums due to the pursuers, the defenders tried to offset the sum that they owed to the pursuers against a debt that the pursuers owed to them. The issue here was that the debts owed by the pursuer was an illiquid debt, and therefore the liquid debt that the defenders owed to the pursuers could not be offset against one another. The Supreme Court held that the liquid debt is one that is certain, while an illiquid debt is one that is not easily quantifiable. The Supreme Court further held that where one debt is liquid, apologies, my lord, that where one debt is liquid and the other is illiquid, offsetting could affect the fairness and clarity of the contract, and therefore they did not permit it. This is relevant here as a Supreme Court decision is binding on all of the lower courts, including the Court of Session, and including the court that we are in today. As they have decided that an illiquid debt cannot be offset a liquid one, this court must be bound by that decision, and therefore the defender's defence to offset the sums due against the counterclaim for faulty tar macadam is irrelevant, and decree should be granted in the pursuer's favour. Having discussed the position of liquid and illiquid debts and how the defenders cannot offset their claim for damages of all of these contracts for goods with the pursuers on the grounds of the contract is disputed, from that, my lord, if you agree with me, I would ask that you grant decree for the sum of £39,600 sterling, as the defender's response to the claims is an irrelevant defence in law. If you are inclined to grant decree, my lord, I would also be seeking for an award of interest at the standard of 8% per annum until the payment is made, and I would also be seeking expenses. With regard to the outstanding issues in this matter, my lord, I would ask that you schedule a proof to be heard at a later date. And unless there's anything further that I can help you with, my lord, I end my debate and you have my submissions.